Good morning, or good second morning. What do the hobbits call that? 11sies? Second breakfast. I was asked last night about Packingham v. North Carolina. Specifically, I was asked about it in reference to the bond requirements for BOW and whether or not Packingham v. North Carolina made the bond requirements on BOW invalid. And I didn't really want to argue it, debate it, so I said no, and I pointed to the test. The test that the court was looking at was a significant government interest, narrowly tailored. It has to be narrowly tailored to achieve a significant government interest. Intermediate scrutiny. Because the court didn't have to look past that one. Now, that might not be the right test. The court didn't have to look past that one because they found that under that test in Packingham, the state had exceeded its abilities. So let's look at what was going on in Packingham. Packingham was a convicted sex offender. And in North Carolina, if you are a convicted sex offender, you are restricted from, maybe as a child molester, I'm not entirely sure, but it was some sex offense. You're restricted from accessing various websites that children may use, if I understand it correctly. Again, I'm not reading it. I'm in my car driving. And the court found that, so after you're convicted, after you're released, you're still essentially banned off the internet. Because name a website where children aren't going to go. I mean, kids might go to the news. They might go to Home Depot. The Home Depot's website. They'll go to Amazon. I mean, they'll go to Facebook. And I think Packingham was actually convicted because he said some, like, praise God about something or the other good thing that happened to me, if I remember correctly. He posted that on Facebook. And, you know, you're a violator, and they're going to crucify him. And so what a lawyer is trained to get out of these cases, because you're never going to find a fact pattern identical to Packingham. What you're looking for is the test, and the test is the same test. It's the court said the state was looking for intermediate scrutiny, but it failed on intermediate scrutiny. Now, what that tells you is that the court wasn't entirely decided on whether or not it should be intermediate scrutiny. It might be a strict scrutiny analysis. It might be. We don't know. But it's still a test. So a law could be crafted in such a way that it is sufficiently narrowly tailored and it serves a sufficiently compelling interest to pass the test. And some real big strikes against North Carolina in this particular case is, number one, that Packingham he'd already done his time. So any restrictions they put on him really had to be narrowly tailored, because this isn't his punishment. His punishment is over. He should be allowed to have all the rights and freedoms of a normal free citizen, unless, as far as the First Amendment is concerned, the state has a sufficiently compelling interest in regulating that activity, and it is narrowly tailored enough. It's sufficiently narrowly tailored to just achieve that compelling state interest without burdening his speech beyond that. And the court pointed out, you know, that you need news, you need to be able to talk to your family members. And to be quite honest with you, like, if I lacked internet, or the ability to go on the internet, I would be very hard pressed to talk to just about anybody I know. So I don't keep very many phone numbers. I don't call people a lot, at least not on the phone. The difference between Packingham's situation and, let's say, Bau's situation is Packingham was convicted of I believe it was a child sex crime. Now, just assuming arguendo that he was in fact convicted of a child sex crime and not some other, yeah, it had to be a child sex crime because he was barred from going anywhere where kids might be. So, assuming that I am correct and that he was convicted of a child sex crime, the state does have a compelling interest in keeping him away from kids. They don't want him to be able to lure kids in, you know, like you see on To Catch a Predator and stuff like that. The state doesn't want him being able to do that. But what the problem was, they couldn't craft their restriction narrowly enough to keep him from just talking to kids. Now, in Bau's situation, Bao was using the internet to convince adults. He was using his freedom of speech, misusing his freedom of speech, to convince adults to harass Judge Peavy. He was actually using the internet to commit his crime, which he hadn't yet been tried on. So, number one, it's going to be a short duration. Number two, it's directly related to what he is in jail awaiting trial for. And number three, it was optional. You may have recalled that he was originally released without that restriction, and he showed that he needed the restriction, and he didn't have to sign it. You may have noticed he didn't sign it. He had the option just to stay in jail, where I am sure his internet access was extremely limited, if not non-existent. I mean, I can conceive of where inmates, prisoners, would only have access to like LexisNexis or Westlaw and not have any access to things like Facebook or I'm sure it's a very tightly monitored system. So those are some big deals. But the overarching issue when you're looking at that case or any First Amendment case is you have to find the test. There is a test in it. And just because in Packingham's particular instance with North Carolina's particular statute, just because that statute didn't pass the test doesn't mean that you can no longer ban people from the internet. Carte blanche. It doesn't mean that. You could have a specific enough test that will allow you to do that. Which also reminds me of the and I know you may not like that, but that's just the way the law works, so you could deal with it or not, your choice. But it also reminds me of the Ninth Circuit Court of Appeals case out of Hawaii, where the Ninth Circuit Court of Appeals found that there is a constitutional right to carry. There's a constitutional right to carry. And because there's a constitutional right to carry, that means that Hawaii's law, where they required a permit to carry, but never gave out the permit, was unconstitutional. And people are like, oh, we're overjoyed. They can't, I have a constitutional right to carry. I get to carry willy-nilly. No, you need to relax on that. It doesn't mean you get to carry willy-nilly. It means that that particular statute by Hawaii, at least in the way it was being enforced, was unconstitutional. If they had been giving out open carry permits at some greater level that the court found to be a reasonable level, or if they had reasonable standards of determining who could or could not open carry, instead of just basically saying no one can open carry, you need a permit to open carry, and by the way, nobody's going to get that permit. So just because that particular statute or the way it was being enforced in Hawaii was determined to be unconstitutional doesn't mean that the statute in California is going to similarly be determined to be unconstitutional, because number one, it's a different statute, and number two, it's being enforced or administered differently. So, again, that's the difference between the way a lawyer looks at it and the way a layman looks at it. And I hope you understand that, or I hope you're beginning to understand that. That's why I love the Second Amendment, and I don't have a problem with open carry. I think it's ridiculous to carry like a long arm down a city street, but I've been in Arizona. People are walking around with guns on their hips, and nobody thinks twice. It's a dude with a gun on his hip. Huh? Is he a cop? I don't know. He's got a gun on his hip, and he's not doing anything wrong. Okay, you know. And reasonable minds, I understand. Reasonable minds can reasonably differ on that. Anyway, that was Packingham, the North Carolina. On that Ninth Circuit case, my understanding is Hawaii's looking for an en-banc, Ninth Circuit en-banc, which means they're going to get like 8 or 9 appeals justices from the Ninth Circuit to review it. I don't know exactly how all that works, but I assume that the Ninth Circuit en-banc would be able to overturn that decision. But I haven't looked into it because it really doesn't matter to me until it's settled, and just because it's settled, it doesn't mean that it's going to have an impact on the laws where I live in California. So anyway, I hope you enjoyed that. I hope that gave you some insight. Remember that there are 3 levels of scrutiny for First Amendment. There is the rational basis test, which is the lowest one. There is intermediate scrutiny, which is where you typically see like a time, place, or manner restriction. And then there is strict scrutiny, where that's typically where it's a content restriction. So there you go. Thanks for watching. Have a great day.